As if the prosecution against James Comey wasn't weak enough, a new document from the feds, the prosecutors, show why this case is doomed. Let's discuss. I'm Dave Ehrenberg, former state attorney for Palm Beach County, a.k.a. the Florida lawman here on Legal AF. We're me at the intersection of law and politics. Hit that subscribe button if you haven't done so already. Let's keep the momentum going. And let's take a deeper dive on a response from the government, the prosecutors, to James Comey's attempt to get the case dismissed because of vindictive prosecution. So Comey's lawyers said that this was obviously vindictive and the whole matter should be tossed by the federal judge. And in response, the government said, hey, we've got real evidence here. I mean, there's evidence that Comey did indeed leak stuff through Daniel Richmond, his confidant, his friend, who served for a time at the FBI with him. And that's what this case is all about. But the prosecution's document, which supposedly shows that there were communications between Comey and Richmond, actually undermines their case. Because although it does show communications, it's not clear whether it's involving leaking to the press. It's not clearly showing any request for Richmond to disclose information to the press. And most importantly, the communications were not when Daniel Richmond was an employee at the FBI. And that's crucial. Because if you look at the indictment, let's take a look at the indictment and you'll see what I mean. The indictment is really sparse, vague, and it never even mentioned Richmond in it. It was unclear whether they're talking about Comey leaking through Richmond, his buddy, or through Andrew McCabe. Remember the whole issue with Andrew McCabe leaking? He did leak, but then he said that Comey never authorized him in advance to do so. He said he told Comey after the fact. But it turns out that the indictment against Comey is not about McCabe. It's about Comey and Richmond. And here's what the indictment says. The indictment says that on or about September 30th, 2020, in the Eastern District of Virginia, the defendant, James B. Comey Jr., did willfully and knowingly make a materially false, fictitious, and fraudulent statement in a matter within the jurisdiction of the legislative branch of the government of the United States by falsely stating to a U.S. Senator during a Senate Judiciary Committee hearing that he, James B. Comey Jr., had not, quote, authorized someone else at the FBI to be an anonymous source in news reports, end quote, regarding an FBI investigation concerning person one. Okay. For purpose of this video, what we're focusing on is whether or not Daniel Richmond was at the FBI. Because if he was not at the FBI at the time the disclosures were made, then the case falls apart. And there are other reasons that this case falls apart. Like I said, vindictive prosecution, I think it's clear to me. Perhaps Lindsay Halligan, the acting U.S. attorney, was not appointed properly. That could get this case tossed. And especially because now this matter is past the statute of limitations. If she's bounced off the case and they have to do it all over again, case closed, it's over, done. But also, there's this matter. Did Comey even lie to begin with if he disclosed stuff to a guy who was not at the FBI? And see, that's another key part of this case. Because, first of all, it's not clear whether he disclosed stuff through Richmond pertaining to the Clinton investigation, the email investigation, or the Trump-Russia investigation. It's not clear whether he even authorized Richmond to disclose. There was an investigation called Arctic Haze, and the FBI said no. Richmond said that Comey did not authorize him to disclose stuff to the FBI, and so they closed the investigation. That's why Bill Barr and John Durham said, no, we're not going to be prosecuting Comey. So what's changed now? Politics. Because the evidence isn't any clearer now than it was back then. And remember, you have to prove these cases beyond a reasonable doubt. And the jury needs to be unanimous. I mean, if there's some ambiguity, if there's vagueness, then you can't prove that he knowingly lied beyond a reasonable doubt. And the evidence is showing that he didn't. Because the question again was, did you authorize someone at the FBI to be an anonymous source in news reports? Well, if Daniel Richmond, who is that person, was not the FBI at the time, then you don't even need to get to the question of whether he was authorized to lie. I mean, first off, it's not clear at all whether he was authorized by Comey. The evidence seems to point to the opposite. But if he wasn't at the FBI to begin with, well, that's the end of this case. And now we have the government's response in opposition to defendant's motion to dismiss indictment based on vindictive and selective prosecution. Okay, so this came out where the government is saying, you see, you got all this evidence, so obviously it can't be vindictive, it can't be selective. We've got the goods, but they really don't have the goods, because in that motion, and I want to give a hat tip to Anna Bauer from Lawfare, who wrote an amazing article about this. Bauer says that a closer look at the actual dates makes the problem for the prosecution plain. In its response to Comey's motion to dismiss, the government cites the following series of interactions between Richmond and Comey, as well as Richmond and others. First, an email chain between Comey and Richmond, spanning from October 29th to November 2nd, 2016. Second, February 11th, 2017 emails between Richmond and Chuck Rosenberg, then the head of the Drug Enforcement Administration. Third, an April 23rd, 2017 email exchange between Comey and Richmond. And fourth, in May 11th to May 17th, 2017 text thread between Richmond and Michael Schmidt, a reporter for the New York Times. Here's the problem. Those last three, from February 11th, 2017, all the way to May 17th, 2017, that was clearly after Richmond had resigned from the FBI. And all you need to do is look back at the Inspector General's report from the DOJ, which did a whole investigation of this. In a footnote, the Inspector General said on page 31 that Richmond's appointment date as an SGE was June 30th, 2015. SGE is a special government employee. This was a special thing that Comey wanted. He wanted his friend there with him, and he appointed him to a position within the Department of Justice, the FBI, and on June 30th, 2015. And then that same footnote says that Richmond resigned as an SGE in February 2017, but his security clearance remained active until he was debriefed and read out by the FBI on July 12th, 2017. So he resigned on February 2017. Now let's go back to the dates that Anna Bauer has mentioned that were in the government's motion. They're talking about February 11th, 2017 emails. That's after Richmond resigned. April 23rd, 2017 email exchange. That's after Richmond resigned. May 11th to May 17th, 2017 text thread. Nope. That's after Richmond resigned. Remember, Richmond unequivocally resigned from the FBI on February 7th, 2017. So that leaves one allegation, one email chain, supposedly when Comey authorized Richmond to reveal confidential information or any information really to the press, as long as the information involved Hillary Clinton's investigation or the Donald Trump Russia investigation. But here's the problem. When it comes to the email chain between Comey and Richmond, spanning from October 29th to November 2nd, 2016, which seems like it would be within the time frame when Richmond was in fact working for the FBI. First off, that email chain, I reviewed it, doesn't authorize anyone to leak anything. They do talk about some media stuff, but it's really unclear whether there was an authorization. And again, that's plenty of reasonable doubt. But even if there was, which there wasn't, but even if there was, that email chain between October 29th to November 2nd, 2016 actually occurred after Richmond left the FBI. Now, here's the thing. Even though he didn't officially resign from the FBI until February 7th, 2017, which meant it was 4 days before the emails between Richmond and Chuck Rosenberg, so he was no longer at the FBI then. But there was a public records request by the Daily Caller, a conservative outlet trying to get Richmond's employee information. And when that was released, well, that provided a lot of important information where there's a document showing an FBI official that noted that Richmond had not signed his renewal, that Richmond's original appointment, which was on June 30th, 2015, was just for 1 year. On June 30th, 2016, a year after his initial appointment, Richmond's term as an SGE expired. And that day, the FBI noted that in memos that he was done. His term has expired. Now, Richmond was not immediately reappointed, and Human Resources they have all these documents showing he is not signed, he is not an SGE anymore, and then you have the FBI official and a handwritten note which was sent to the Daily Caller, which said this, quote, document drawn up and sent to OGC Office of General Counsel for Richmond's signature, never signed, never officially reappointed after June 2016. So, are you going to prove beyond a reasonable doubt that he was when there's ample documents that he wasn't? Are you going to say that, well, he was at the FBI, but he wasn't employed there? Then what does at the FBI mean? What? You have the t-shirt? What do you think it means? You think you're going to prove that Comey leaked information through Richmond, which we don't have any evidence of that pertaining to Hillary Clinton's investigation or Trump's investigation, and it occurred when Richmond was at the FBI? Not a chance. Oh, and then there's the whole vindictive prosecution, selective prosecution thing, and the Lindsay Halligan not appointed correctly argument. This case is going nowhere. The question to me is not if, but when this case gets dismissed by a judge. I don't think it will even go to a jury. I don't think that James Comey will hear the words not guilty by a jury because I think a judge is going to throw it out. And there's plenty of reasons to throw this out. The evidence just is not there. The appointment of Halligan, suspect. Vindictive, selective prosecution, clear. Not good. And we'll keep following here on Legal AF. I'm Dave Ehrenberg, a.k.a. the Florida Lawman. If you like this video, please like, subscribe, share with a friend, leave a comment below. Also, check out my Substack for more content at Dave Ehrenberg. You'll find me there, and you'll find me here at Legal AF next time.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.